Yes, sir. Good morning.
Good morning, Chief Justice. May it please the Court. Peter Heffernan on behalf of the Committee for Public Counsel Services. Your Honor, the underlying matter here is an adoption proceeding initiated by the guardians of the subject child, to which the indigent father objected. And because the father objected, the court was required to proceed with the adoption to consider termination of parental rights under Section 3A of the Adoption Statute, Chapter 10, 210. The court, in this matter, appointed counsel to the child and the father. There is no established right to counsel under Section 3A, and in the Probate and Family Court, some judges are appointing and some judges are not.
Can I just ask you a question? With respect to the child, if this were the department seeking to terminate, would the child by statute get counsel? Is that right?
That is correct, Your Honor.
So, but the problem here is there's no statute. I mean, the parents are a different matter, but with respect to the child, there's no statute that applies when you have a situation like that.
That is correct.
And so then that's why you need to, in your view, it becomes a constitutional question because there's no intervening statute that solves the problem.
Correct, Your Honor.
And I gather the Constitution must be ours in view of Lassiter.
Indeed, Your Honor. We're talking about the Massachusetts Declaration of Rights and JKB and the reasoning in JP with respect to the due process need for counsel. And at the outset, I'd like to just make two brief points. We're talking about a very small number of cases under 3A annually. The Probate and Family Court does not break down their adoption proceedings, but their highest estimate is no more than 100 cases annually of contested private adoption. And even a smaller number of those would be involving indigent parent respondents. To put that in context, there's more than 8,000 child welfare cases, care and protections, and SHINs combined filed annually. So we're talking about a small fraction of the overall child welfare appointments statewide. Additionally, the CPCS already has a system in place for assigning and paying and compensating these attorneys. There would be no additional or very little additional administrative burden as a result of extending the right to counsel in these cases.
When you say paying these attorneys, you mean you have that system vis-a-vis when the department is seeking it? Or do you mean that you have it for these kinds of cases as well?
We have it for these kinds. We already have a list. Each court, each probate and family court in the Commonwealth has a list of certified attorneys that are certified for these cases as well as termination cases in another context.
Okay.
Now, the consequence of what you're asking for, I gather, is that when a guardian seeks to adopt, and that would result in the termination of parental rights, then the parents would have attorney appointed for them, correct?
Correct, and the child.
And the child,
yes.
But not necessarily the person seeking to adopt.
No, Your Honor, and I think the bright line between is the fundamental rights at stake. The petitioner in this case does not have a fundamental right to family integrity with respect to an existing parent-child relationship that is at risk through the court order of being extinguished personally. I think that is the bright line between the appointment, Your Honor's question.
If the parent in this kind of situation, or when the department is seeking to terminate, if the parent doesn't object, does it ever happen that the child, and then the child doesn't get counsel, correct?
That is correct. There is no right to counsel in consented adoption proceedings, and we're not.
So the parents control the whole. I mean, in that sense, the parents control the situation.
For children that are 12 and under, that is the case. Children that are over 12 have the right to consent. They can't be adopted without their consent.
So then, even though the parent might agree, the child would get counsel in that situation?
I'm not sure how that situation would be dealt with in the. I think by statute, if the child withholds his consent, I'm not sure there's a mechanism to override the child's consent. Your Honor, due process requires the appointment of counsel.
Before you get there, I gather that this would not have any effect. No, I'm sorry. The procedure that you would be in place is the parent would have to come to court and say, I object.
Yes, Your Honor.
So it would also, the counsel would be appointed only upon the parent pro se coming to court and saying, I object.
That's correct. In this case, the father received notice of the adoption petition. He filed his objection, and that would be the point at which the court would appoint counsel for that father and for the child in that proceeding. Your Honor, this court in JKB held that a parent facing the permanent loss of their parent-child relationship cannot have a meaningful right to a hearing without the assistance of counsel. And by its reasoning and its holding, it applies to all proceedings under Section 3, Section 8 proceedings and Section B. The court doesn't distinguish between those two sections of the statute. It does state that the need for counsel is particularly so where the state, with its resources, is the petitioner, but that does not make the need any less so with respect to other contexts. And it's important to note that the reasoning of JKB, the complexity of these cases, the significant rights at stake, and the state's interest in having these cases carefully and correctly decided applies to both proceedings under 3A and 3B. And while JKB only addressed the question of the right to counsel for children, I would argue that its reasoning and holding apply equally in the context of I'm sorry, parents. I apologize.
Right, yeah.
With respect to parents, I argued that it applies equally to children. In fact, even more so where a pro se parent at least has the opportunity to stand up and present his or her position to the court. A child without counsel has no voice in these proceedings. The state has recognized the need for having children have a voice in child custody proceedings by providing for a right to counsel in many other contexts where the right to counsel is not, where the rights at stake are not nearly as dire.
A question about right to counsel for children who are quite young, under the age of 4 or 3, can't articulate their positions. In Massachusetts, we've said that counsel represents the wishes of the client.
Yes, Your Honor.
And when there's an incompetent, like a very young child, you need a GAL. Isn't that correct?
Not necessarily. We are a substituted judgment jurisdiction where the counsel, the job of counsel is to determine were the child able to speak. It's not necessarily what's in the best interest of the child. The analysis is, were that child able to communicate to me what he or she what his position is, what would that position be? And there's a distinction between that and clearly a best interest, what would be best for this child. The obvious example is an aunt of limited resources as opposed to a foster home with more resources. The question is, given all things considered, the child standing in that child's shoes, the prior relationship with that aunt, et cetera, may lead the child's counsel to find that the child's position is for placement with the relative as opposed to a foster placement.
We've articulated that the attorney does the substituted judgment, or
Yes,
that the substituted judgment is made.
The attorney, in that case, substitutes his or her judgment. Well, under that analysis, the attorney reaches the position of the child. The reasoning of JKP applies equally to children as it applies to parents, and that is the same complexity of the cases and the same rights at stake. Further, Your Honors, the statute creates a classification between two similarly situated groups, parents facing and children facing the termination of their parental rights or the parent-child relationship are similarly situated regardless of whether the proceedings are under 3A or 3B. Because this classification in disparate treatment, where counsel is provided under 3B but not under 3A, because this affects a fundamental right, the appropriate level for review in equal protection analysis is strict scrutiny. And here, there is no compelling state interest to deny counsel to this small category of litigants, given that the rights at stake are so significant and the cost to the Commonwealth is relatively small. Thank you.
Thank you
Your Honor.
very much.